welcome to our webinar. I'm Kulsoom and Hadi, Knowledge Counsel in the Incentives and Remuneration Group here at Travers Smith, and today I'm joined by Elissavet Grout, who's a Senior Counsel in the team.
Hello.
In our webinar today, we're going to look at social security and the issues that UK employers with staff working in the EU, EEA or Switzerland need to think about. Currently, although the UK has left the EU, we're in a period of transition which is due to end at the end of the year on the 31st of December. And at the moment, during this transition period, not a great deal has changed. But unless the UK manages to negotiate an agreement on social security before the end of the transition period, and that's looking increasingly unlikely, UK employers could find that they and their employees are at risk of paying social security in more than one country. So in this webinar, we're going to look at these risks and consider the steps that can be taken to deal with them. So Elissavet, before we look at how things might change next year, perhaps you can give everyone a brief reminder of the social security rules that currently apply to UK employees and employers in the EU.
Of course, and thank you very much, Kulsoom. So as you've already mentioned, while we're in the transition period, UK employers have to continue to apply the EU social security coordination rules, so the EU rules. And these rules make sure that businesses and employees together only pay social security contributions in one EU country at a time, and particularly double charges are not permitted. So the starting point is that social security contributions will be paid in the country where the work is carried out. And this is irrespective of where the employer is based or where the employee lives. So for example, if you are a UK employer with an employee working in France, that employee will only pay French social security contributions, and the UK employer will also have to pay into the French system. Crucially, however, no UK NICs are payable at the same time. Of course, working arrangements aren't always as simple as this. You could have a situation where an employee works in more than one member state. For example, which is quite common, 3 days a week in the UK, 2 days a week in France. And where this happens, the EU rules say that social security should still only be paid in one country, and that would be the country where the employee lives, so long as they carry out a substantial amount of their working activity in that country. There are, as you can imagine, special rules to determine where you spend your substantial amount of activity. Quite often, and most often in a business sense, the employer will second or post an employee to another country for a short period of time to fulfill a business need there. This other country is often referred to as the host country. And the EU rules recognise that there isn't a lot of point in the employee that is going for a short period of time to start paying social security in the host country, because they are unlikely to benefit from that in the long term. Therefore, the rules say, provided certain conditions are met, the employee and their employer can continue to pay social security contributions in the home country, the country from which they were seconded or posted. These are known as the posted worker rules, and they apply typically for assignments that are less than 2 years and where the employee has not been specifically sent to replace another employee. They also only apply if the employer that's posting the employee maintains an employment relationship with them. So they must continue to pay them, and they can also continue to terminate the relationship should they wish to.
So is this where a Form A1 becomes relevant?
Yes, that's right, Kulsoom. With posted workers, the approach that you have to take across the EU is to apply to your local tax authority, so HM Revenue and Customs here in the UK, for a Form A1. This form is also sometimes called a certificate of coverage. And this form is used as evidence that the EU rules that apply to posted workers are applying to your situation. And it means that when you have this form, the local tax authorities in your host country will not seek to charge you any social security contributions. It's relatively easy to apply for this form, and it's before the employee starts their posting or secondment abroad, because otherwise you won't have evidence of the position, and the local tax authorities may seek to charge you for social security contributions, which you then will have to claim back.
And you come across A1s in the context of posted workers. Are there other situations where you can apply for them as well?
There are other situations. So for example, if the first secondment over 2 years needs to be extended, and there are certain special circumstances that mean that that should be extended, for example, the individual concerned has some specialist knowledge or skills, then the parties can apply to the tax authorities for an extension, and it's in a fresh form. Equally, if you are in the situation we mentioned earlier about an individual who works in 2 different member states at one time, and you need to prove that the member state in which you live should be the one that charges you social security contributions, then again, you have to apply for a Form A1 as evidence of this.
So we've all got used to this Form A1 process, and I have to say, in my experience, it works pretty well. What's going to happen at the end of this year?
Well, that's the million-dollar question, and it's very difficult for employers to prepare because all the details aren't known yet. As far as we're aware, social security agreement hasn't yet been reached. A lot of the focus of the government is clearly on trade negotiations. And what we also don't know is whether the trade negotiations and the outcome of those will include agreements on social security. In an ideal world, regardless of where we end up with trade, it would be the best position where the UK and the EU could agree to continue these coordination rules from applying. However, in the meantime, we have to work on the basis that this isn't going to be the case from 1st of January 2021. And we have seen very recently HM Revenue and Customs publishing a lot of material requesting that businesses get ready and helping them with how to do this. So that to me seems to suggest that they are also not expecting an agreement on social security anytime soon.
So does that mean that there's a possibility of having to pay 2 lots of social security?
Well, I think in most scenarios, this is going to be unlikely because the default position will stay the same. Social security will be paid in the country where the work is performed. But as we've been discussing, difficulties will arise for individuals who work in more than one country and also those who are posted to work in a country for a short period of time. Because in these cases, the local position in each country will determine the social security liability, and there will no longer be an overarching agreement between tax authorities to eliminate double tax charges. So they could, in theory, arise.
And what's the local position in the UK?
Well, what the UK has chosen to do is to unilaterally adopt the EU Social Security Coordination Rules into EU law. And this means that from 1st of January 2021, the UK intends to apply these rules to UK employees going to work in the EU and EU employees coming to work into the UK. This appears to mean that when a UK employer posts someone to work in France, in the circumstances that we discussed earlier about posted workers, the UK will expect the employer and the employee to continue to pay UK social security contributions on the basis that it's a short-term posting. There will be no reason for the French tax authorities to recognise this arrangement, and so they will be entitled, under their local law, to impose French social security contributions on the same amount if they wish. So after years of working under a system where double tax charges or social security charges are designed to be eliminated, most businesses are going to find this quite a difficult step change to cope with.
The UK's got quite a few bilateral social security agreements with countries outside the EU. Do you think there's the likelihood of the UK entering into similar agreements with EU countries on a country-by-country basis?
Yes, and in fact, the UK has entered into one already with Ireland, which effectively keeps the position between UK and Irish nationals the same as it currently is under the EU rules. Now, this is very good news, but we have realised that the way this agreement has been drafted, it doesn't include or doesn't cover those EU citizens who have obtained settled status in the UK in order to protect their immigration position post-Brexit. So that means that those individuals who currently will have a right to live and work in the UK will not be covered by this bilateral agreement with Ireland. So if they are subsequently posted from the UK to work to Ireland, they won't be able to take advantage of the arrangements under that agreement. It is unclear to us whether this was a deliberate choice or whether it was simply an oversight.
Yeah, that's not very helpful, is it? Definitely something companies need to look out for. So in terms of Form A1s, though, if they've been issued by the EU or UK tax authorities before the end of the transition period, do they continue to be good for the rest of their duration, even after the end of the transition?
Yes, we understand the way in which the withdrawal agreement between the EU and the UK has been drafted, and this is the agreement that was originally signed back in January. It creates a protected group of individuals, and included in that protected group is individuals who are currently working under cross-border arrangements, in particular under A1 arrangements. So those, we believe, will continue to be recognised by the UK tax authorities until they come to an end, even if that means that they will come to an end after the transition period has finished. Having said this, whilst the reverse should also be true, so if you have an A1 that has been issued by the UK and you are working under it in France at the moment, it is expected that the French tax authorities would honour that A1 form until the end of the period to which it relates. However, we have heard from local advisors that this isn't guaranteed. And so in each member state that you may have employees working under an existing A1, we are advising our clients to seek local tax advice to ensure that the local tax authorities will continue to honour it.
All this uncertainty with only a few weeks to go before the transition period ends is it's not good news for UK employers, is it? What do you recommend that they do to protect themselves?
Yes, well, if they haven't already been doing this, I suppose a good place to start is to identify what type of cross-border arrangements their employees are currently working under. And this really should form part of a larger immigration check, because as we all know, the rules on immigration are also changing. So for EU employees who are working in the UK at the moment under an existing A1, we believe no immediate action is needed because the UK tax authorities should honour that existing A1 until it comes to an end. However, as previously mentioned, for UK employees working in the EU under an existing A1 form, we have been advising employers to find out whether the local tax authorities would continue to honour that A1 form after 31st of December this year. If the answer is no, then obviously plans will need to be put in place to ensure that the correct social security is paid in each country. For new postings in the new year, employers should check whether there is a risk of a double social security charge. With the right planning, it should be possible to avoid this happening. However, in many cases, employees who would otherwise be able to continue to pay into the UK social security net may find themselves having to pay social security contributions in their host country at possibly higher rates than in the UK. This means that with senior executives, it may be necessary to compensate or equalise those individuals for those higher rates for the period of time that they are working abroad.
So Elissavet, what about directors coming to the UK to attend board meetings?
Well, the rules that apply to employees apply equally to company directors, even those who are non-executive directors, which means they do not have an employment relationship with the company that they serve. However, company directors from outside the EU have historically benefited from an arrangement with the UK tax authorities so that they do not have to pay UK social security in certain special circumstances. In effect, this would apply to individuals who attend no more than 10 board meetings in the UK per year. This is a concession, and it remains to be seen whether it will be extended to company directors coming from the EU after the transition period ends. Special advice should be taken because by no means is this a certain outcome.
Yes, it'll be interesting to see whether they do extend that concessionary treatment. And as you've mentioned before, social security is just one part of the puzzle, as it were. Tax considerations have to be taken into account. Of course, they're not subject to coordination rules. And as you've mentioned, the immigration position will be quite different from next year as well. So that will also need to be checked. So thanks, Elissavet. That's all been great advice. Clearly, there's lots of things to think about, and we'll keep monitoring the situation and we'll let you know if there's any change. Thanks very much for your time today and for listening to this recording, and goodbye.
Goodbye.